Sometimes, though not very often, the corporate entity sponsoring an employment visa for a foreign national employee working in Hong Kong may undergo a reorganisation or a repositioning in relation to its operations here, and consequently it can be no longer said that the party serving as the sponsor of the original visa permission is the party that's actively engaging the services of the employee, nor indeed possibly even carrying on a business in Hong Kong any longer. An example of this could be where a foreign company sets up an entirely new commercial operation here and then transfers an employee from their overseas business to oversee their market activities in Hong Kong. At this part of the exercise, the company will have applied for and secured an employment visa for their intercompany transferee staff, and the business will be now well and truly off to the races. However, soon afterwards, the advisors in the home country realise that the manner in which the Hong Kong entity has been established is not advantageous for taxation purposes, and they then seek to reconfigure the international group structure before the business goes too far down the commercial path that it's treading. Consequently, they then decide to incorporate a new, alternate Hong Kong entity owned and configured in a fashion that's different from that disclosed to the Immigration Department at the time that its bona fides as a suitable sponsor for foreign national employment visa permissions was being established, when the intercompany transfer and visa approval was granted to their first staff in Hong Kong. In this situation, the employee and the employer have an obligation to report these material changes in circumstances to the Immigration Department and in the process undergo what's known as a technical change of sponsorship application. This requires the employer and the employee to report the facts of what's gone on corporately, submitting information setting out the details of the change in the sponsoring entity, and also evidence that, for all practical purposes, the terms and conditions of the sponsored employee's employment in Hong Kong have not changed at all as a result of this international corporate restructure. This type of application usually takes 3 to 4 weeks to finalise and is processed via the residence section on the 5th floor of Immigration Tower.